Thank you all. Please be seated. This is a time set for oral argument in our case number CACV 220180FC, Dilday versus Dilday. Counsel, good morning. Each side does have 20 minutes to argue on behalf of their position. Appellant, you can reserve a portion of your time if you wish to do so for rebuttal. But if you wish to do so, you need to keep track of your own time at the podium clock. Out of respect for counsel and also to avoid embarrassment, I would ask that folks in attendance make sure their cell phones are off so our proceedings are not being interrupted. And also, please understand we've reviewed the briefs, we've conferenced the case, we're familiar with the case. We'd ask you to keep that in mind as you present your arguments. Proceedings are being recorded, will be posted to YouTube in due course, so please, as you begin your presentation, please tell us your name and the party that you represent. With that, and Mr. Ciola, am I pronouncing that close? Chola? Very well, you may proceed. Thank you.
May it please the court, Jason Chola for appellant Sean Dilday. I would like to reserve 2 minutes of my time for rebuttal. This is a case about the special master not following the evidence. Now, there were a number of issues addressed in both opening and cross-appeal briefs, but I would like to address this issue in 3 distinct areas. First, the special master had an inadequate justification for the division of community property and debts. Second, the special master improperly determined the waste of community assets. And third, the special master reached erroneous conclusions about Mr. Dilday's income and Mrs. Dilday's needs in awarding spousal maintenance. So first, to address the division of community property, there are 2 sub-issues here that I want to touch on. First relates to the denial of Mr. Dilday's Bobrow claim for reimbursement for Porsche payments, and the second relates to the division of personal community property. Regarding the Bobrow claim, this is somewhat intertwined with the spousal maintenance issue because of the way the special master dealt with it, treating those payments as additional retroactive maintenance on top of the $3,500 a month of maintenance that wife was awarded retroactive to basically the week after service of her petition. Ultimately, though, how these payments are categorized is immaterial. The issue is that Mr. Dilday received no credit for making them. So the Porsche payments were community debt, and by tacking on 100% of that payment as additional spousal maintenance, that debt wasn't equitably divided. It was instead assigned 100% to Mr. Dilday, defeating the purpose of Bobrow by putting him in the same position as if the payments were treated as a gift. Again, whether these payments are treated as retroactive maintenance or simply a reimbursable expense, our position is the end result is the same, that $11,176.11 needs to be deducted from some amount of money flowing to Mrs. Dilday from Mr. Dilday so that there is an equitable distribution of the community's debts. Ms. Dilday cited in her answering brief to Barron v. Barron and Huey v. Huey in support of the way the special master applied these debts to the retroactive maintenance. But these cases are not only distinguishable, they actually highlight the error in the special master's decision. In Barron, the trial court there found that the wife should have received temporary maintenance, but she didn't. So the $30,000 of community debt that the husband in that case was requesting reimbursement for was just simply treated as those retroactive payments she would otherwise have been entitled to. And in Huey, the husband in that case requested reimbursement for community debt payments that he was ordered to make early in the case, and he was ordered to make them in the context of spousal maintenance. So he was always obligated to make those debt payments as maintenance. That's distinct from the situation in this case where Mr. Dilday was never ordered to make the payments and where Mrs. Dilday was awarded retroactive maintenance based on the special master's interpretation of her needs. So instead, by ordering that Mr. Dilday assume 100% of the debt for this Porsche payments, she received an additional unnecessary about $11,000 of retroactive maintenance above.
Counsel, aren't you just really asking us to reweigh how the trial court decided to allocate that additional amount of the debt and said, look, this is also going to be part of the maintenance because it was still an amount that had to be paid that she didn't have the resources to pay? How does it matter?
Judge, we're not asking the court to reweigh the debt. We're asking the court to reweigh the evidence. We're asking the court to correctly give Mr. Dilday credit for those payments. So the special master determined that her need was $3,500 a month, and then he just lumped the $11,000 in equalization for the Porsche payments on top of that without finding any additional need for that money. They were also in financially similar position as the special master found later with regard to the award of attorney's fees, because Mrs. Dilday had received close to $1 million in cash from being bought out her equity in the marital home and from the parties' joint bank accounts.
But the $11,000 you're talking about is part of the entire equitable resolution. So how is it that $11,000, the way the court handled it, not within its sound discretion, and we would have to reweigh it otherwise?
Judge, because it was above and beyond what the special master found to be Mrs. Dilday's needs. So again, our position is that simply he needs to be credited with that $11,000, whether that come off of the retroactive maintenance so that he ends up paying a total of $3,500 a month, assuming the court doesn't disturb that award later, as we're essentially requesting to, or whether it be equalized in some other way. Our position is that he just needs to have credit given for that payment that he made.
Wasn't there disputed evidence about the use and the ability to use and other things with respect to this car?
If the court is referring to the fact that after Mrs. Dilday basically turned it in, Mr. Dilday retained possession of it, I don't know that there was a dispute. I think it was, or at least my recollection is that it was relatively agreed upon that he had possession of it. But my understanding, my reading of the relevant cases is that would not be a material distinction, because it was still a community debt obligation that he took on to ensure that they didn't default on this debt and have a community detriment as a result. So because the special master did not apportion this debt equitably, we believe it was erroneous. Moving to the division of personal property, this was erroneous because the special master made no effort to engage in an equitable distribution of the personal property. He basically just said, I can't tell the value, so I'm not going to try and figure it out. You all keep what you have. But this approach ignored the requirement of an equitable distribution, and ultimately, if this approach is endorsed, it would result in bad public policy because it rewarded whichever party may have walked away from the separation with more possessions in hand and penalizes the party who may have let this happen to avoid immediate conflict.
And the standard for that is an abuse of discretion, correct? You're arguing that the special master abused his discretion, not that he was required to do what you're asking?
Correct. Well, we are arguing that it was an abuse of discretion because he did not equitably divide the property.
And that the discretion that was abused, from your perspective, is he should have taken an inventory, if one was possible, of all personal property held by both parties, and then divided things.
That would have been one solution. Yes, that would have probably been the easiest solution here, is to inventory the property, identify if there's any dispute over whether it's separate or community in nature, have it appraised, sold, and then split the proceeds. That would have resulted in an equitable division and probably an equal division of the personal property.
What's your best case for what, and by that I mean opinion, for what the special master did here being an abuse of discretion?
I don't have that at my fingertips. I can review that and then respond on rebuttal with a case citation. This is not necessarily an answer to what you asked, but Doe v. Blair at least supports the proposition that we're asserting that the special master could order a sale of the community property.
And I'm with you. There's no question he could have. What I'm looking for is sort of more why he had to here.
Thank you. I will respond to that.
Let me follow up on that question, which is, if you're saying there's an abuse of discretion here, what evidence is there that somehow this didn't result in an equitable resolution? Your client has at least some insight into what the personal property is.
Right. The evidence is basically a lack of evidence about the value. So the special master concluded he was unable to determine the value, and so if we can't determine the value, we have no way to know if it was equitable or inequitable.
Well, whose burden is it to produce the evidence? The special masters or your clients to say, look, this is the evidence of what the value is. And this makes it inequitable to just tell us to keep what we have.
I suppose it would be the party's burden, and Mr. Dilday did in fact produce some evidence of valuation. I can't stand here and say that I know for sure he produced all the evidence, but he did provide evidence, some receipts of what certain items of property cost, and the special master found that even with that information, he was unable to determine the value. But again, it's our position that if you're unable to determine value, that doesn't mean that there's no further requirement to engage in an equitable division. As I mentioned a moment ago, and as Judge Thuma raised in...
So short of ordering a sale of everything, I mean, what is a judge supposed to do when the parties don't bring the evidence necessary? And this is not an unusual situation. As is often said, the best evidence in a family court matter is in the parking lot in a glove compartment. It's not in the courtroom.
And I have certainly noticed that in my practice so far. I don't know that I have another alternative, best case scenario, or an alternative means, but...
So is your argument then at its core, it was abuse of discretion not to order a full sale? It seems to me that's where we end up.
Effectively, yes. It was an abuse of discretion to not order a full sale or do anything that would result in an equitable distribution. The full sale is the best answer that I have come up with to result in an equitable distribution in a situation like this where the value the special master concluded was unknown. So I think we've covered my points on that topic. So to move to the waste of community assets, the special master found that Mr. Dilday committed waste of $1,567,45 of community funds from 6 different categories of waste. Now, to be clear, there are 3 portions of this waste finding that we're not contesting on appeal. One is $90,000 worth of the payments to Mary Hahn. Second is $3,792 worth of unreimbursed funeral expenses paid to Mary Hahn. And third is $25,010 of legal fees paid in relation to the Mary Hahn lawsuit. So we're acknowledging that $118,802 was waste, but we contest the remaining $1,448,243 was waste. Now, of those 6 items, the one that I want to address is the missing payroll. It was an error for the special master to conclude that the missing, what was considered missing payroll of $1,060,132 was waste. This was income that Mr. Dilday had received from paychecks that the parties cashed to facilitate their practice of frequently paying cash for community expenses, which was contested to some extent. Mr. Dilday testified that they kept large amounts of cash on hand and that they resorted to using cash after dispute with a creditor. He testified that his wife was not only aware of this $1 million+ of income, but that she actually cashed some of the checks herself, which again was disputed. But he also testified that they frequently used cash for a variety of expenses, and he specifically identified $232,000 worth of various cash purchases, improvements to their community property, or maintenance like landscaping, various purchases of personal items and other things, and some of their lavish vacations. Now, for her part, Mrs. Dilday did acknowledge that they had safes installed in the closets of their home, and that they used some cash during the dispute with the creditor. And she even agreed that they paid landscapers $50,000 in cash. But ultimately, the $1 million was considered waste because she testified that she didn't know about it and that she disputed their practice of using cash after the creditor dispute. But the record shows that neither of these are true. She actually contradicts her own claims about this cash.
But didn't all the things you're going over now, didn't the special master have the ability to judge the credibility and whatever evidence they brought forward and make those determinations? And as I think has been asked already, why are we kind of rehashing that evidence to reweigh it so that your client comes out on top on that issue?
That's correct, Judge. This information was presented to the special master, and we're not asking the court to remake credibility determinations, but his conclusion has to be supported by the evidence. And so our position is that, especially because of the contradictions in Ms. Dilday's testimony, his conclusion was not supported by the evidence. And so one of the contradictions was that when discussing spousal maintenance, she claimed to be accustomed to a $1.1 million per year income lifestyle. But the problem with that is the only way that she could have known and been accustomed to that level of lifestyle is if she actually knew about all this missing income. Because there's a chart on appendix page 188 that shows that Mr. Cantor prepared, where he showed $2 million of income that he was able to trace to various bank accounts and $1 million, the missing income, that he was unable to trace anywhere. So the problem with her testimony is that the missing payroll constituted a full 1/3 of Mr. Dilday's take-home income in this period. And we raised an issue in our briefing that we believe Mr. Cantor double counted some of the waste expenses. But for the sake of argument, if we assume he did not double count, that means there was another $460,000 worth of income that wife would not have known about.
But, well, she wouldn't have known during the marriage, but by the time she testified, a lot had come out about the bank account that had not been disclosed. She could have said, look, what I know is the income that was coming in is the income we lived on, and now I know basically she was saying, and it was 1.1 million, which is an accurate statement because that's what he was in fact earning. That
would have been an accurate statement after the fact of his earning, but I don't think it would have been an accurate characterization of the lifestyle that they lived, especially because if you take for the...
And your client, I assume, made that argument below.
That
she would not have known the 1.1 million, and that this was an amount that was inaccurate, and the special master got to consider that?
Mr. Dilday argued that she knew about this 1.1 million, the missing $1 million of income, yes.
And so, aren't you just asking us to reweigh the evidence? You got the chance to make the argument. The special master heard the evidence, understood what both parties said, understood there may have been some inconsistencies, and I think fair to say on both sides, and came out with a conclusion.
We're not asking the court to reweigh the evidence. We're asking the court to consider that in light of all the evidence, there was not substantial evidence to support the special master's conclusion and that it was erroneous as a result of that.
If we accept your client's testimony was true, we have to accept your client as true.
To some extent, but we also look at Ms. Dilday's testimony. So when I say to some extent, I mean in part. Ms. Dilday's testimony also supports the conclusion that she was aware of this income. So if we subtract from the $2 million, the $500,000 that we believe was double counted, that means that a full 50% of his take-home income would have been unknown to her.
Well, what I think it was fair for the special master to say is she knew there was some cash. She knew they kept some cash at home. She knew they paid some in cash, but that's not the same as saying she knew there was extra income that was in a different bank account. And that was what was happening. And she disputed cashing the checks. She disputed that. Again, we're just into what the special master considered, and you're asking us to reweigh it.
Our position, again, is that we're asking the court to find that this didn't result in substantial evidence. I understand that that's a fine distinction to draw, but one of the other issues with her testimony, though, was that she disputed the fact that they used cash in general, but when she was asked about this on direct examination, she stated that, no, they didn't use cash because she, quote, loved using credit cards. But her own expert's report proved that was false because it showed that over a 6-year period, she had cash withdrawals of over $500,000, which was 3.5 times higher than her credit card expenses in the same period of $158,000. So we believe that her contradictions were sufficient, rise to the level that there's not substantial evidence to support the special master's conclusion. I see my time that I wish to reserve for rebuttal is about here, so I will stop at this point. Thank you.
Very well. Thank you, Mr. Chill. I realized, counsel, after I called the case, but during opening argument, that we have a cross-appeal here, too. I apologize for that. Appellee, cross-appellant will have rebuttal time if you wish to reserve it. And, counsel, I'll be a little more generous than the 206 for you. When you get to rebuttal and answering for the cross-appeal. I apologize for not noticing that earlier.
Thank you. No worries. Appreciate it.
Mr. Berkshire.
May it please the court, Keith Berkshire for the cross-appellant, Brooke Dilday. I was going to actually ask that to reserve the time anyway, Judge, so thank you for beating me to it. As for the appeal, I'll start with the personal property issues. If you looked at the exhibits on this, husband provided 10-year-old receipts of purses that had pictures of, used purses and shoes. This is one of the few appeals that I get to do that I was actually trial counsel. So the evidence on this was pictures of their closets. My client testifying that husbands, bought 80 suits worth $2,000 to $5,000 a piece. And the court looked at it and said it's used furniture, and I'm not going to use 18-year-old in one situation. I think an 18-year-old receipt, and based on the pictures, it looks like you guys have the similar amount of stuff. Like most family court trials, we're not going to appraise used furniture and clothing because it doesn't make a lot of sense. So the court looked at it and said, neither of you presented evidence that this is disparate, so we're keeping it in place. The quote to Dole v. Blair, Dole was my case, and that was just you actually have to divide property, not that you have to do some sort of appraisals or so forth. Dole was the court didn't order the parties to keep houses together for 6 years, not that it didn't allocate clothing. So as for the personal property, again, the court looked at the evidence. There was a lot of testimony about it. There was pictures of their closets and watches and stuff. The court, and they analyzed it as best they could. As for the Porsche payments, the court went through exactly what this court in Huey said to do, which was analyze spousal ability to pay, who had the car. I'll point out that, wife returned the car to husband because he had a tracking device on it and was tracking her, and then he got to use the car. So the court looked at it, looked at Bobro, mentioned Bobro in the decision, and while Huey wasn't out yet, when this trial ruling was out, it did exactly what this court said to do at Huey. So there is no error there. The biggest part, obviously, of appellant's case is this waste claim, and this is where all of the testimony went. In the original case, which is shown in Exhibit 187, which included the affidavit of husband's mistress, who was a stripper when he met her and started supporting her, her affidavit in the civil lawsuit was that he gave her $450,000. We could not prove that amount. We proved only as far as to Mary Hahn was, $187,000 or $87,000 to her. We proved, but what we did show through an expert who testified that none of this money went into accounts was this $1 million plus of excess payroll. My client had no idea about it. She testified about it, that there was no idea. They went through and showed that it didn't go into a single account. Husband's main excuse at trial was that at one point at the very beginning of this time period where this missing payroll was done was that he was involved in a lawsuit and wanted to essentially hide money from a creditor. But he couldn't explain why then for the next, I forget, it was 7 years or something after the date that lawsuit was cured, that he continued to do this practice. The court utilized Gutierrez, which says if one party can show where there's some excessive abnormal expenditure or hiding of money, then it's the burdens on the other party. And husband couldn't show where $1 million plus went. There was extensive charts and testimony. They reviewed all the bank statements, credit card statements out of these time periods. That's what Mr. Cantor did, is coming up with his expert report. Said, I have no idea where this money was. And so the special master appropriately put the burden under Gutierrez on husband and said that it was his obligation to prove it. Wife testified, and the court found specifically that wife testified credibly that this amount of cash was not utilized. And so at the end of the day, the waste issue, and especially the use of cash, was a credibility determination. As for the next parts of the payments to the other parts of the waste claims, was other transactions that again, Mr. Cantor specifically testified were not double dips of the missing payroll. These were specific transactions. This case, husband fought a subpoena that was to his brother because his brother was being paid by his corporation, coincidentally the exact same amounts that Mary Hahn was claiming to. We got this Bank of America account that was in the name of his brother that was transfers to Miss Hahn that, again, husband fought the subpoena to get it because it showed that this is one of the methods that he was using to support his mistress during the case. Husband had severe credibility problems. I mean, there was testimony about how, he was telling Ms. Hahn that my client was dying of cancer, and that's why this was all going on. I mean, the facts of this case are pretty egregious, even for what we see in my practice. I mean, they were sued from a explicit video of where husband was taping Ms. Hahn and had the lawsuits, and that was part of the waste claim, was the legal fees that were used to defend that case. So at the end of the day, this was a case where, when the special master looked at all of the circumstances, including the uncontested circumstance where he was supporting this woman and said, this is your burden and you didn't meet it. The court had explicit days of testimony on this. Sorry.
So on the double dipping, and just to cover this, because some of the payments that were also included in the waste were paid from the Bank of America account, which is what appears to create the double dip question. If I paid these attorney's fees from the account that you say is where I put the money that I was wasting, how is it not double dipping? Is that a credibility determination? Because I don't notice that the expert gave much explanation.
He didn't, but the special master did go through that and discuss how this wasn't a double dip on some of these payments, because again, it was credibility of husband saying where this money came from. And now some of it was essentially his brother acting as if he was somehow an employee in the business paying these expenses. So there was testimony about how some of this was from Worldwide Express and that it was essentially illegitimately being expensed out to his brother, and so that should have been income. Some of it was credit cards. There was the other, like for example, one of the expenses was this $40,000 check that came out of an account. Well, that specifically couldn't have been the $1 million, because the $1 million didn't go into any of the accounts. So that was, this $40,000 gambling out of this account. So, I mean, there was a lot of, this whole case was just credibility. I mean, it was down to, on the spousal issue of what husband's income was, where he's saying he's earning $65,000 a year, but he's spending $20,000 a month on credit cards, or his AFI is showing $12,000 a month in expenses, but he's earning $5,000. I mean, that's where the special master hit him on, including the spousal maintenance, analyzing his income, saying this makes no sense that you're spending $20,000 a month. You're gambling at some points after the date of service when you're saying you're making $60,000. He had some points that he was gambling $100,000 at a time. And so the court obviously had credibility issues with him, and that's why overall it was his testimony wasn't credible on it. But specifically on those double dips, David Cantor did go through in his report say what he did to exclude these, that it was from the business or from a credit card or from a different source to specifically try not to double dip. And again, some of David Cantor's, I'd point out that some of the claims we made on waste and gambling and other things were discounted by the special master. They didn't give us all the waste claims. There was another couple $100,000 on gambling and other expenditures that were not given to us because the special master found that we could not prove those. So it wasn't some wholesale adoption of an expert report by any means. There was, and even during the testimony, Mr. Cantor admitted one or two double dips that he then retracted and changed his report on. But again, to your question, Judge Goss, he did testify about it, and it was covered in the report, and I think it was just a credibility determination where husband couldn't point to where this money came, and it put husband in a tough spot. You can't say, well, I got this money from all the excess cash I kept, because when he said he didn't have any excess cash. So he couldn't explain where the money came from that those expenditures, that additional 200-something thousand, came from.
So let's move on, if we could, to the settlement agreement, your cross appeal.
So the main issue, the cross appeal in this took a interesting procedural standpoint. This is before I was actually trial counsel, and they went to essentially a temporary orders agreement or temporary orders hearing, where this was then briefed after the fact with some exhibits. Our position, I guess, cross appellee's answer to us is that somehow Hefner applies, and that Hefner is more specific than Jurek or one of the cases that we cite. Hefner was, frankly, somewhat of an enigma case in looking at Arizona law on what occurs during marriages as presumptively community. And that's because the facts of Hefner made it so clear that it was a personal injury lawsuit specifically. This is not. This was unquestionably The lawsuit was filed during marriage, 1 month prior to the date of service. His entire employment with this company was during marriage. That's undisputed. Claim number one, if you look at Exhibit 187, which is the culmination of all the pleadings in the civil case, including amended complaints and so forth, claim number one is for lost wages in an amount in excess of what the settlement was. So this is an employment lawsuit. Claim number one is lost wages. Now, there are some defamation and all the other subsidiary claims that you'd expect in this, but there's no question here this wasn't a personal injury settlement. And if you look at the settlement agreement, there is one that's parsed out for this future non-compete that we didn't challenge. We said, even though some portion of it may be community, a non-compete with limiting your future actions, fine, it's separate property, 25-211, 25-213, you're doing that. But the base of the claim was...
Are you bound by the allocation in the settlement agreement?
No, I don't believe so. And I think that, I mean, we'll see what the Supreme Court say on the Sowards case, because that's another... when that comes out, I mean, that's a totally different situation because the wife actually signed off on that agreement versus here, they did not. But I think that, you know, one of the things that the trial judge said in the original hearing is super apt as far as what, you know, the terms of the settlement agreement. And the trial judge originally said, so when he was talking about the settlement, so that's what the attorneys come up with. I didn't know what it was. So smart attorneys could word this however they wanted. And wife wasn't part of it. I mean, so again, we start from a presumption it's community. Jurek makes it clear any wages, lost wages, or anything are community. Hefner is the enigma because Hefner goes down the line from Jurek that says, if it's your body, it's your personal property, you got damaged, it's personal. But that's not what the underlying claims here are. All of them are based on employment. So we have to start from the main premise that it's presumptively community. And if it's presumptively community, then the only factual findings in this case were not actually made by Zarzinski because he refused to rule on this. He found it was more of a horizontal appeal, which is fine. But then the only actual ruling on this was after the evidence and testimony at the original hearing in front of Judge Mandel, where he said, while some portion of these money may include some of father's compensation and commissions earned during marriage, there's no definitive manner for the court to make that calculation. Indeed, ordering that some or all of the portion of the settlement proceeds to be community without any evidence of which claims were valued at what amount would be pure speculation, something the court will not do. That's fine, but he applied the burden wrong. So if that's the only factual finding, that there is no evidence. Remember, wife tried to get into the settlement documents, tried to get in the communication with the attorneys. Husband wouldn't let her, so claiming privilege. So here he's using the shield of, I'm not going to let you into this, but I'm not going to tell you what it is. And so how they negotiated this is irrelevant. If husband thought that this was majority separate, then he should have disclose the documents to do that. In refusing to do so, the presumption's community.
So is the solution then, assuming you're right, that we reverse and remand and let the trial court perhaps even decide to hold further hearings on the issue?
I think
further evidence?
Our position is that there are factual findings that the court can't tell, and therefore under the proper burden that it is since the court made findings that I can't tell what this is and there's insufficient evidence, I don't think Husband should be given a separate shot at the apple or bite at the apple at this, because the court said I can't tell what it is and just applied the burden wrong, which means I can't tell it's all community, but for the 112.
That argument, and I understand what you're saying, but that wouldn't apply to the portions of the settlement agreement you didn't engage in, right?
We're not going to challenge the 112 again. I mean, that 112 we said was separate. We said it in multiple pleadings. I said it in my objections. We're bound to it. We even said it, I believe I even said it in the pretrial. So we're bound that is not, that the non-compete, we're not going after that.
And I believe they conceded the same with regard to the wages.
The one part of it, the 388, I think it was not contested as well. But there's another million, I believe, was the number. It's $1,050,000.
It's a significant number.
Yeah, it's $1,138,000. Yeah. Was the rest of it that was done. And one of the reasons I obviously am going to say that I believe I should be bound to the pretrial is because I'm going to turn around and next say that husband should be bound to the pretrial, which is related to the house. Now, the house issue is an interesting issue from the standpoint of just a logistic standpoint. It's if you look at the pleadings around the time that they settled this issue of equity out of the house, wife needed money, wife claimed spousal maintenance, husband claimed he was broke, which later we find out it's not true, and so she agreed to take equity instead of spousal. The court couldn't have been clearer when it allowed this. I mean, it specifically said that I'm keeping jurisdiction. I mean, again, our main position is that the husband's pretrial at the actual trial says, in the uncontested, it says the court specifically retained jurisdiction over the residence for equalization payments that may be owed from father to mother. So the famous case on this is obviously the Leathers case. You're bound to the pretrial. One of my cases a little over a year ago, the Larchick, sorry, I always want to use my client's name first. Larchick v. Pollock case, where this court held that if the parties took a position regarding that a business went up during in their pretrial statement, they were absolutely bound to that again. So we believe that the position in the pretrial and in husband's separate portion, where he argues that it shouldn't be sold, he never argued there was never jurisdiction on this until actually at the trial. That we think that he should be bound to the pretrial on that. But more importantly, again, the court specifically stated in its ruling, or in the hearing where this was all discussed, that it says something to the effect, hey, if there's a big waste claim and husband owes wife $500,000, I may have to order the sale. So claiming later that they didn't, I mean, that was part of the one transaction where she was ordered to sign a disclaimer, because that's the only way that you can refinance. This isn't the Thomas case where they voluntarily did it. This was a contingent deal, whatever you want to call it. It was part of the same transaction, because otherwise it really makes no sense of, if the court didn't have jurisdiction to deal with this house anymore, then what the court order was that husband can't take any more loans on it and he can't sell it, that was part of the court's order as well. It couldn't do that. There's no way to do that if you didn't have jurisdiction over this asset. What really happened in this hearing, and it's evident from the transcript, at the beginning of the transcript, is basically the parties met with the court offline to come up to settle this, and then they went and read it onto the record with the agreement and so forth. And the court clearly memorialized that with this statement that I'm going to keep jurisdiction over it. And so given the facts of this case, given the waste...
Well, isn't that part and parcel of the Rule 69 agreement, which is binding on both parties at that point?
Correct.
So there's a Rule 69 agreement that is enforceable. There's a pretrial where they are bound by their assertions in the pretrial, and you put them both together, it's retained jurisdiction or authority.
And that was our argument, Judge Goss, was that it's not just she signed a disclaimer deed, that was the only part of the agreement. Ours was the agreement, what the judge said, the pretrial altogether is the overall agreement, because that's what, again, the court ordered. I mean, it's axiomatic to say the court could say, hey, husband, don't put any more liens on this and you're not allowed to do anything. You got to tell her what you do with the money. If it's separate property, the court have no authority to do that. But since it's the same transaction, we believe that it's all part of that together. I will reserve my minute and a half.
Very well. Thank you, Mr. Berkshire. Mr. Chola, yeah, I'm going to give you 7 minutes, 2 plus 5 for the rebuttal and for the answering part of the cross appeal. And again, I apologize, counsel, for not alerting myself to that as we started.
That is perfectly fine, Your Honor. I'll wait for the clock.
Very well.
Okay, so to start with, I'll answer Your Honor's question that was posed the first time I was up here, which was the best case to support that the special master's division of property was erroneous. And I can't necessarily vouch for this as the best case in general, but it's the best case I could put my fingers on, and the time I had was the Weinger v. Weinger, held that the trial court is not required to divide community property exactly equally as long as it does not create a gross disparity or make its award arbitrarily. And again, our position is that this award of personal property was made arbitrarily. And I understand that Ms. Dilday's position is that these were old receipts, it was old furniture, it's not worthwhile to have it appraised, not worthwhile to look at these receipts, but we have to keep in mind the context of this party's economic situation. I mean, we're not dealing with my IKEA couch and my Outlet Mall Brooks Brothers suit. We're dealing with expensive designer items that are far more worthwhile to look into their value and far more meaningful as a result to arrive at an equitable distribution. So Dole v. Blair may stand for a number of things, but the reason I brought it up is that it also stands for the proposition that the court can order the sale of community property to arrive at an equitable distribution. And again, that's what we believe should have happened here, is that the court should have ordered an inventory and sale of these luxury items and assets to arrive at an equitable distribution. There was the notion presented that because cash is hard to track, if you can't track it, it's waste. We believe there were two errors with this. First, that husband did present some evidence as to what this was. But second, and perhaps more significant, is that this court has already recognized in the case of Baum v. Baum that the Arizona statutes don't intend to require that all married persons keep detailed account of the money they spend during marriage. Now, that was said in the context of treating presumption of gift of separate property used to pay community debts during a marriage, because you don't want to have a marital relationship broken down to an arm's length business transaction, business relationship. But essentially that's what the special master required here by holding that because cash is hard to track, it must be waste, or finding that. And so we believe...
Well, it wasn't just that. It's when money isn't disclosed to the spouse, and he found that the money wasn't disclosed, then you may want to keep track of it, because later on you may have to account for it. I mean, isn't that a fair statement of what happened here?
That's I think would be a fair statement of his conclusion, but again, we take issue with the finding that Ms. Dilday didn't know about this income in the first place.
Right.
And so as a result of that, we believe it would not be properly considered waste. Regarding the issues raised on cross-appeal, I want to touch on the lawsuit proceeds. So the trial court correctly considered the lawsuit proceeds, or at least the contested portions of the lawsuit proceeds, to be separate property. And as noted, some of the proceeds were kind of acknowledged to be separate property below, some were acknowledged to be community property below, but the remainder still were Mr. Dilday's separate property, and they were presumptively separate property twice over. First, these proceeds were received and the settlement agreement was entered into after the community was dissolved. And so ARS 25211A2 and 25213B both instruct us that that's presumptively separate property. Now, in argument, Ms. Dilday has tried to categorize these and classify these proceeds as something that Mr. Dilday was contractually had a right to, had a vested property interest into because of his employment. But that only applies to the portion that was treated as back wages. The remainder were not back wages, and they were not a property right that he had before entering into the agreement.
But again, are we bound by husband's allocation and the employer's allocation in the settlement agreement? Do you have a case that says we are?
I don't know that
What the trial court is, I should say.
I would frame the answer as it was mother's obligation to prove that these were community assets because they were received after dissolution of the marital community.
The lawsuit was based on what happened during the marriage, correct? No dispute.
Correct.
And it was based on employment issues that accrued during the marriage.
Employment issues and issues that arose from the relationship of employer-employee.
During the marriage?
During the marriage.
Because he was terminated then.
Correct.
And so there may be valid claims that some of it was for future actions, and they've conceded that point. How is the balance, and I believe it's $750,000 that remains.
Yes.
If my math is correct. How is that not open to the burden of proof on husband, not wife, to prove the allocation?
Again, the starting point statutorily, because these proceeds were received after the community dissolved, is that they are his separate property, and it's therefore her burden to prove that it's community property in nature. Second, as we noted in our briefing, you can look at the terms of the settlement agreement and determine what each claim was paid for. So there were the
You're
claims.
right, we can, but that gets back to Judge Goss's question. What meaning does that have to the court in family court? I mean, what you could envision a world, I'm not saying that's the world we're in, but where, you know, someone in the position of your client would allocate everything in a way that was sole and separate and then go to family court and say, Judge, there's nothing to see. It's all mine.
Right, but he didn't. And we know that because there was
I understand that, but that wouldn't be binding on the Superior Court, would it?
The terms of the settlement
The
agreement.
hypothetical that I mentioned where everything is allocated in a way that it's beyond reach of the other spouse.
I don't think it would be necessarily binding on the court, but you would have to look then at the other factors, when it was received, the context of the dispute, the claims that were raised in the lawsuit, and what the settlement agreement resulted in. I see my time is running out as I finish this sentence. So thank you.
Very well.
Thank you.
Thank you. Mr. Berkshire, rebuttal on the cross appeal.
It was received after marriage. The lawsuit was filed during. She met her burden by just showing it was filed during and the claims were during. I mean, this is the Garrett PI, you know, the famous about the PI contingency fees that were received after the date of marriage, that she met. In that case, this court held that they met their burden by showing that these things accrued during marriage, and he had to separate it out. And this court in Garrett even said it's his burden to show completely what had to be separated out from that. And again, it's when did the claim accrue? I mean, this court, in the last 6 months, another one of ours, the Brucklier case, said that, you know, talked about when did title accrue on a residence, and they said it was when the right arose. It's much like a pension, and we cite the DeFrancisco case, I think, or something to that effect in our brief that shows
it accrued before the marriage, therefore sole and separate.
Correct, but in here, there's no question that the claims accrued during the marriage. This was from employment that was 100%. It doesn't even get to the Garrett issue of there was before and after and try to allocate it. There's no question here that this was completely separate. And again, it's really juric. I mean, it really comes down to this is a juric case where the Supreme Court held that anything that was personal injury he had to prove. And
so, is a defamation claim personal? Because that's part of this is, you know, allegations of defamation, invasion of privacy. Those seem to be personal claims.
I think it could be. And this is where I think that the Hefner distinction, where Hefner was kind of the odd man out of these cases, because Hefner was so clearly completely primarily personal injury that when this court sent it back, they're like, well, wife still gets to do those claims. But here, in all other cases that we cite to, it's really the other way. And again, claim one, lost wages that are in excess of the amount claimed specifically numerically in excess of amount of the settlement.
Thank you, counsel. We appreciate your briefing. We appreciate your presentation today. We'll take the matter under advisement. We'll issue a written ruling in due course. Court stands in recess while we set up for next oral argument. Thank you.